If you are writing a case about individuals or an organization, you're going to need some type of approval in order to use it. Now, as I mentioned in an earlier segment, when you're dealing with a research case, you normally try to get that approval before the research begins because you do not want the results of the research determining whether or not it gets approved or not, which could easily happen. With a discussion case, however, typically the approval process occurs at the very end, and that is the focus that I will have in this final segment of the case writing checklist. So, getting approval for a case normally is not that difficult, particularly if you're dealing with a small business. If you're dealing with a large business, it can be a lot more complicated, and the most chilling words to a case writer is, let me check with legal before I make a decision. But if you're getting approval for a case, there are a number of issues that you need to think about, and some of these you might not think about if you don't have a checklist. And I think this is one of the more useful aspects of this checklist. First thing you need to do is you need to think about copyright. What I normally do is I normally hold the copyright of a case that I'm going to publish until the publisher publishes it, in which case the copyright gets turned over to the publisher. In some cases, an organization might want to hold on to the copyright of a case. If that were to happen, then the organization might preclude the case from being published. What I would say, though, is I usually give duplicating rights to an organization, which is to say, hey, look, even if I turn over the copyright, I will always do it with the understanding that you have the right to make as many copies as you want. Most journals and repositories and so forth understand this, and they're not going to have a problem with this, but they may have more of a problem if you try to get it later. So I tend to do that up front as soon as I'm ready to release the case. Now, something that can be very significant is the right to recall a case, and typically I give that to an organization up to the point where it's published. I actually ran into this situation a few months ago where a company basically said, well, you know, our product has evolved so much from the case, we were wondering if you could take the case down. And I explained that the case had already been published, that they released it for publication, and that if I were to take the case down, A, I couldn't get rid of all the copies on the internet, and B, it would create a hole where that case had formerly been and raise a lot of questions. Well, why did the organization take the case down? It wasn't that they had any complaints with the case, it's just that the case described a technology that was a year and a half older than their current technology, and they didn't want people getting the sense that their technology was less sophisticated than it currently is. Once I explained that to them, there was no problem. But nevertheless, it's something you want to have clear because this is something that can cause problems in the future if an organization doesn't understand it. I usually request the right to make non-material changes to the case, typically limited to changing typos, misspellings, this sort of thing. If I don't have that right, then I have to just leave them there or else go through the release process again. And I've never had any problem getting this, but if I did not have it, then I would not want to do any edits to the case. Consequential damages, if you have a case, you never know what that case is going to be put used to. You don't want to be responsible for it, and they don't want to be responsible to any damages to your career caused by publishing the case. I usually just put some weasel words in the agreement saying neither of us will hold each other to this, or we'll hold each other harmless, or something like that. And then finally, good faith in arbitration. I normally put in some words to the effect that if there's any dispute that relies on this case, we'll go to arbitration. It's never happened. I don't think it ever will happen. But once again, what you want to do is you want to avoid a situation where a company perceives that being involved in developing a case would lead to some legal liability, because if it does, then they're just going to believe it's not worth participating in the case writing. And that's one of the reasons why it's often much easier to get cases done in entrepreneurial situations than in large organizations, because entrepreneurs tend to worry less about this stuff than large organizations, possibly because entrepreneurs frequently have less money to worry about and they don't perceive themselves as being a target. But these are the things that you want to think about. In my book, Informing with the Case Method, I have a kind of a sample letter that you might be able to use to release a case if you wanted to, and that might be a good idea to use something along those lines just to get yourself covered. And there are some journals and repositories that will not publish a case if they do not have some sort of release document, because they do not want to be held liable by an organization that claims that nobody had permission to release all this information. So, as I mentioned at the very outlet of this series, the case writing checklist has lots and lots of items in it. It is very rare that you have to worry about all of them in any individual case situation, but on the other hand, I would say that every one of them has come up in some case or other that I've been writing. And so, as a consequence, it's probably a good tool if you're thinking about the case writing process for the first time.